Johnny Depp has been having a lot of fun with the hearsay rule in his ongoing trial against his ex-wife Amber Heard. Today we'll talk about that. We'll talk about the hearsay rule in the context of that case, what Depp has said, and what the lawyers are doing. We'll start with Georgia's definition of hearsay, because the definition of hearsay doesn't change a lot between state and federal or state and different state courts. This comes from the Official Code of Georgia, annotated 24-8-801, and it defines hearsay as a statement other than one made by the declarant, which means the witness in this context, while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. In a minute, we're going to break that down and look at some of the different parts of that definition and how they apply. But first, let's watch a video clip from TikTok of Johnny Depp's adventures with the hearsay rule.
My former business managers were quite disturbed the
Hearsay.
island.
I don't think it's hearsay.
He asked her what she would like for him to cook. That's hearsay, I guess. They looked at papers, maybe they're hearsay papers, I don't know. Photograph of,
Objection, Your Honor. Also hearsay.
he'd had a conversation with Ms. Heard.
Hearsay, Your Honor. Can we watch it again?
Oh, I've
Play
seen
it
it,
again,
honey.
Michelle. A mega.
So that's the hearsay part of that video, and you can see that Mr. Depp is a pretty smart guy. He's like figuring out the hearsay rule on the fly. This is the way they teach it in law schools. Here's the basic definition. It could vary a little bit from one jurisdiction to another, but it's basically an out-of-court statement offered to prove the truth of the matter asserted. And this definition has three parts, so I've underlined them here. Out of court means it's a statement made outside the court, and that sounds fairly clear, but it distinguishes it from regular testimony. If this was a car wreck case and we were arguing about what color the traffic light was, if I'm the witness and I'm in court and I say, that light was red, well then that's not hearsay because it's an in-court statement, not an out-of-court statement. But if I'm in court and I say, my wife told me the light was red, well then that's an out-of-court statement. And so that could constitute hearsay. If I'm in court testifying, and even if I say, later that night I told her the light was red, that would still be hearsay because I'm sitting there trying to recite or give testimony about a statement that I made out of court. So that's the first element of the hearsay rule, out of court. Next, statement. It has to be a statement. Generally, a question doesn't constitute hearsay. So I might say, later that night I asked my wife, what color was that light? And that's usually not going to be hearsay because that's a question and not a statement. This last part is a little bit trickier, and it's kind of a fun example because we have a great example of this in the Johnny Depp trial. But it's not hearsay unless it's offered to prove the truth of the matter asserted. So to go back to the simpler traffic light thing, let's pretend that if this is a trial about what color the light was, and I say, my wife told me the light was red, then that's hearsay. But let's pretend the trial wasn't about the color of the light at all. Instead, let's pretend that the issue in the trial, for whatever reason, is whether I was actually present there at the intersection where the collision occurred. So if no one really cared what color the light was, but the issue in court was whether I was at the intersection at all, then it might be permissible or allowable for me to say something like, I told my wife the light was red. Or someone could say, I heard Jeb tell his wife the light was red. Because we wouldn't be trying to prove the truth of the matter asserted in that hearsay sentence. We wouldn't be trying to prove the truth as to the color of the light. We just care about the statement because it reveals whether I was present at the intersection. So the Johnny Depp trial gives us a really nice example of this. Some of Amber Heard's lawyers' cross-examination of Johnny Depp has involved old articles like this. So this is an article from 2014 about Johnny Depp allegedly being drunk at the Hollywood Film Awards ceremony. Now, whether Depp was drunk at the Hollywood Film Awards ceremony in 2014 doesn't matter. And it's irrelevant to the issues in the case about whether Ms. Heard impermissibly defamed Mr. Depp. But it matters for this reason. Johnny Depp's claim is that Amber Heard damaged his reputation by going public with these false allegations of domestic abuse in 2018. So his whole point, the whole point of the trial is for him to say, she has damaged my reputation. And Amber Heard's lawyer is trying to make the point that, according to him at least, Depp's reputation was already pretty bad before then. So he brings out this 2014 article about Johnny Depp being drunk at the Hollywood Film Awards ceremony. Not because it matters whether he was drunk there, but because this shows, according to Heard and her lawyer, that Depp's reputation was already damaged. So this article, it's out of court, right? Everything in here was written out of court. It's all statements. So it could constitute hearsay, but it isn't hearsay because they aren't offering it to prove the truth of the matter asserted. They're not offering to prove that he was drunk, just that his reputation was already trashed long before Amber Heard made these allegations of domestic abuse in 2018. So that's why it's not excluded by the hearsay rule. We'll watch another video here. This is an unusual one. It doesn't appear that Amber Heard's lawyer is very familiar with the application of the hearsay rule. Let's watch him work through it here.
And isn't it true that in the entire time you were there, you were not informed as to what caused damage to Mr. Depp's finger on March 8th?
Objection, hearsay.
I'm asking what he wasn't told.
Sustained objection, next question.
You didn't know what could cause damage to Mr. Depp's hand while you were there on March 8th, correct?
Dr. Kipper told me he sustained an injury on one of his
Well,
fingers.
objection, hearsay.
But you asked the question.
Oh,
Next
okay. He said he sustained an injury to his finger.
Yes.
So the problem here is that Heard's lawyer is trying to object to his own question. You don't really get to do that. As a lawyer, if you ask a question and the witness is trying to answer your question in the most natural and reasonable way, you can't object to their answer because you asked the question. So we would say by asking that question, Amber Heard's lawyer opened the door to whatever the answer was because he didn't have to ask it. So if he asks it, then he has to sit and listen to the answer, even if it includes hearsay.